I'm absolutely delighted to be here, though I really, really wish it was in person. And I hope there'll be opportunities to celebrate Anne in person at some point in the future. So thanks so much to Sarah for inviting me. Sarah asked me to speak about the law relating to synthetic gametes, but taking on board Robin's point from this morning about the loaded term synthetic, I'm going to speak about stem cell derived gametes. The law here in some ways is extremely clear and straightforward. It's possible to carry out research into the production of stem cell derived gametes under license from the HFEA, so that's possible. That obviously is useful for basic research, and in the future it could also be useful for generating perhaps a supply of eggs to be used in research. But it's a criminal offence to use stem cell derived gametes in treatment. So it can be licensed for research, criminal offence to use in treatment. This is achieved, Sarah Chan mentioned this morning, so just recapping, the way this is achieved under the legislation is through the 2008 amendments to the 1990 Act, which introduced this rather strange concept of permitted eggs, which have to come from the ovaries of women, and permitted sperm, which must come from the testes of a man, and a permitted embryo, which must be created through the fertilization of a permitted egg by a permitted sperm. Anything else cannot be used in treatment services, and it would be a criminal offence to do so. So this is how the prohibition of reproductive cloning has happened since 2008. Wouldn't be a permitted embryo, therefore cannot be used in treatment. Okay, so that's clear so far. What's really important and I think interesting about this prohibition is that it's quite an unusual one in the statute. Many other prohibitions which are on the face of the statute can be changed by regulations, and this one can't. And what that means, to say it could be changed by regulations, is that it would be possible to alter the rule through a much less intensive parliamentary scrutiny than you get with primary legislation. So it's faster and it's easier to change the law through regulations than it is through primary legislation. But with this one, there's no regulation making power. So if there is a desire to change this prohibition in the future, you would need full primary legislation. So in 2008, the government was challenged on this prohibition by someone familiar to many of us, Evan Harris MP. So he said, why not include a regulation making power here? And this is the then minister's response, that basically there needed to be full parliamentary scrutiny of such a change because it would significantly change the way people have children. Now, as Azim mentioned this morning, this is all a very, very long way off. But how would it change the way in which people have children? Well, there's lots of possible reproductive uses in the future of stem cell derived gametes of varying degrees of controversy. So, for example, it could eliminate all the issues that accompany treatment with donated gametes. I mentioned already the possibility of same-sex reproduction to enable two men or two women to have a genetically related child. Could also, of course, facilitate postmenopausal reproduction, enabling older women to have babies. Then you get to the more far-fetched scenarios, reproducing with oneself, not cloning, but still, I'm sure, unadvisable. The suggestion of what's been described as multiplex parenting, where you have multiple people involved in the genesis of stem cells, derived gametes, and then to derive an embryo from that, which is then implanted. So you could also use that, it's been suggested, for selective breeding, either breeding in vitro or through creating a very large number of embryos for PGD. As I say, this is all a very long way off, and some of these far-fetched suggestions are even further away, I'm sure. But there are, I think, two really interesting legal questions aside from the need for primary legislation. And one is to do with the question of parenthood. If you derive stem cells from an embryo, would that embryo be a parent? Is there a sense in which stem cell derived gametes have the capacity to degender genetic parenthood? So terms like mother and father, are they still necessary? Are they perhaps becoming redundant? This is really, really interesting in the light of a case I'm sure many of you are also familiar with, recent case in the UK courts, where the courts have decided that the word mother is not in law the word for a female parent, but is the word for the person, man or woman, who gives birth. So there are some really interesting questions going on outside of what we're talking about today about the terms mother and father. Then there's also a really, really interesting clash on consent that would have to be resolved if we were to get to this stage. The clash is basically this. Consent under the 1990 Act to the use of gametes and embryos in treatment must be in writing, and it must be specific. You can't give a very vague general consent. It has to be specific and it has to be in writing. On the other hand, consent to the use of cells in stem cell research has to be unconditional. So, for example, this is HFEA license condition. No control can be given to people over the future use of stem cells. So consent to stem cell research has to be unconditional. So this means we're going to have to make a choice. You can't have at the same time no control over future use at the same time as the need for specific consent in writing. You're going to have to choose. It's going to have to be one or the other. My guess, and it is obviously just speculation, is that it's likely that consent to reproduction will take priority because consent has been said to be one of the pillars of the UK's regulatory framework under the Human Fertilisation and Embryology Act. But this does lead, I think, to some interesting and rather perplexing questions. If gametes could be derived from stem cells without somebody's knowledge, without the tissue donor's knowledge, would it matter then if they were used in reproduction without the person's knowledge or consent? And that raises really interesting questions about whether or not you can be harmed if you never find out that stem cells derived from your tissues have been used in reproduction. Now, of course, you could say, well, of course, this happens already. People can find out many years later that they reproduced without knowing. But this could obviously be on a much greater scale and outside the context of a previous sexual encounter. There's also the really interesting question of if we ever were to get to the stage where primary legislation were going to be passed in order to facilitate use in treatment, what would those uses be? Would we confine their use to the replacement of donor gametes for infertility reasons for same-sex couples or even for older women? Would legislation want to exclude some of those more far-fetched uses? And that raises, I think, rather another really interesting question about is it logical to be relaxed about facilitating one parental preference for genetic relatedness while not facilitating other sorts of parental preferences? Does that line make sense? And some people would say it does, and some people would say it doesn't. And just to conclude, in short, and to return to the Minister's answer to Evan Harris in 2008, I think the really interesting and big question raised here is, does it matter if we significantly change the way in which people have children? So I'll stop there.